If the goods transferred or the transportation takes place, then the buyer will be having the risk or the responsibility of the goods. Express conditions and warranties are those which have been expressly agreed upon the parties at the time of the contract of sale. Once if it is unconditional, if it is deliverable, then automatically the property or the goods will be transferred to the buyer when the contract is made. Hello everyone, I am Arun Kumar, lecturer in Department of Commerce and Management, Vidhyaashram First Grade College, the Temple of Excellence, MYSURU. Dear students, welcome to this new session on unit number 2, session 2. The topic is the Sale of Goods Act 1930. Yes, dear students, in the earlier session we discussed about what is this Sale of Goods Act 1930 and which was the law we were following before the enforcement of the Sale of Goods Act 1930, and also we discussed about the definition of the Sale of Goods of Act 1930 and also the essential elements and the difference between the sale and agreement to sell. So these are all the topics we discussed in the earlier session. So in this session we are going to study about the conditions and warranties. So what is this conditions and warranties? We all know that what is conditions and what is warranties. While they are selling the product, when the seller selling the product, on certain conditions he'll sell the products, or on certain conditions the buyer purchases the products. Warranties. Who give the warranties? Yes, the seller give the warranties to the buyer on the product. Whatever you're going to purchase, for example, if you're purchasing a cell phone, he will give the warranty of 2 years for the cell phone, but with some conditions, right? So what this Sale of Goods Act 1930 says about this conditions and warranties. So stipulation. The first you have to know the meaning of stipulation, then you will easily understand the meaning of conditions and warranties with respect to the sale of goods. So stipulation means a requirement or a specified item in an agreement. Yes, stipulation in an easy way you can say condition. Okay, stipulation is nothing but conditions. So stipulation means conditions are required specified item in an agreement. Conditions are requirement. In a contract of sale of goods, stipulation refers to representation made by the buyer and the seller reciprocally as a part of negotiation between them before they enter into a contract. So here the buyer and seller, they come together and they have some conditions each other, then they proceed with their buying and selling process, right? So those conditions are called stipulations with respect to conditions and warranties in sale of goods. So meaning of conditions and warranties. So first we look into conditions. Okay, what is this conditions? Conditions is nothing but, so according to section 12 subsection 2, a condition is a stipulation essential to the main purpose of the contract, the breach of which gives a right to repudiate the contract. So condition is nothing but what? Here condition is a stipulation essential to the main purpose of contract. So if you understand the example, easily can understand what is the meaning of condition. So B wanted to purchase a car. B wanted to purchase a car suitable for touring purpose. So Mr. B wanted to purchase a car which is suitable for touring purpose, and Mr. M suggested him a Bugatti car. B purchased the car from Mr. M, a car dealer. Mr. M is a car dealer. Mr. B wants to purchase a car, but he wants to purchase which kind of car? He wants to purchase a car which is suitable for tour and trip purpose. So Mr. M suggested to purchase Bugatti car. So he purchased it. After some use, the car was found unfit for the touring purpose. Yes, the car was found unfit for the touring purpose held. There was a breach of condition. Yes, here in case, okay, while you are selling the product, the customer say this kind of specification product we want. If you provide the same specific particular product, then it's fine. If you are not providing the same specific product, then it's a breach of contract. Okay, that is what section 12 subsection 2 says about conditions. Next, looking into warranty. So what is this warranty? Warranty is nothing but, according to section 12 subsection 3, a warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives a right to a claim for damage but not right to reject goods and to treat the contract as repudiated. That means here in conditions, if whatever the conditions applied, if those conditions are not satisfied, they can avoid or they can reject the product. But here under warranty, if the warranties are not fulfilled by the seller, then they have the right to reject goods. They will be having the right to reject goods and to the contract as repudiated. Okay, they will not be having the right to reject the goods. Under that, they can reject the goods. Under conditions are not fulfilled, they can reject the goods. But under warranty, if the conditions are not fulfilled, they can sue for the damages, but they cannot, reject the goods. Here you can see the example. Mr. X purchased a car from a dealer with assured gifts and discount schemes. Dealer defaulted in delivery of those schemes as intended. There is a breach of warranty. Yes, here there is a breach of warranty. At the time of purchasing the car, he promised that he will give some gifts. Okay, he assured that he will give some gifts and discounts at the time of purchasing car. But after purchasing the car, he failed to give those gifts. Okay, that is a warranty he had given. So for that, what they can do? They can ask for the gifts and discounts, but they can't, reject the goods. That is called warranty. Moving further, express and implied conditions and warranties. The conditions and warranties may be express or implied. Express conditions and warranties are those which have been expressly agreed upon by the parties at the time of the contract of sale. That means express conditions and warranties are those which have been expressly agreed upon the parties at the time of the contract of sale. So here at the time of contract of sale, those terms and conditions are agreed by both the parties. At the time of contract of sale, the conditions are agreed by both the parties, by the seller as well as by the buyer. But implied conditions and warranties are those which the law incorporates into the contract unless the parties stipulate to the contract. They may be cancelled or varied by the express agreement or by the codes of dealing or by usage and customs. So here the express conditions are at the time of contract. The implied conditions and warranties are those which the law incorporates into the contract. That means the law will be attached to the contract unless the parties stipulate to the contrary. That means here at the time of purchasing only, everything is already included. The warranties, guarantees, everything is already included. That means the product is inclusive already. Before selling itself, it's already inclusive of conditions and warranties. Okay, but under express conditions and warranties, at the time of purchasing, they are going to come into an understanding about the conditions and warranties. So express is nothing but, express conditions and warranties is nothing but, at the time of selling a product, the condition warranties will be discussed. Implied conditions and warranties is nothing but, before the selling the product itself, all the conditions and warranties are already attached with the product. Transfer of ownership in goods. That means, what is this transfer of ownership with respect to sale of goods? So in a contract of sale of goods, there are three stages in the performance of contract by a seller. There are three stages in the performance of contract by a seller. transfer of property in the goods. Yes, there are three stages in transfer of goods or transfer of property of goods. Transfer of possession of the goods, transfer of possession of the goods, and passing of the risk. The expression transfer of property means the transfer of ownership of the goods from the seller to buyer. So to constitute the buyer the owner thereof. The time at which property passes from the seller to buyer is important due to the following reasons. So what does this transfer of ownership says? Transfer of ownership is nothing but, here you can see, transfer of property is nothing but transferring the ownership of the product from the seller to the buyer, and from there on the buyer is going to be the real owner of the property and is going to have all the responsibilities of the property. So the time at which property passes from seller to buyer is important due to the following reasons. Yes, at what time the property is transferred to the buyer, he really is the owner of the product from now onwards. To know this all, we have to look into the following reasons. So which are those reasons? The first one is risk prima facie passes with property. So risk prima facie passes with property is nothing but section 26 provides that unless otherwise agreed, the goods remain at the seller's risk. The goods remains at the seller's risk until the property therein is transferred to the buyer. Yes, the goods remain at the seller risk until the property transferred to the buyer's place. So if you are a seller, if you are owning the property or the goods, yet it is under your risk, your responsibility until you transfer it to the buyer. The goods are at buyer's risk whether delivery has been made or not. Okay. So once if the goods transferred or the transportation takes place, then the buyer will be having the risk or the responsibility of the goods. That is called risk prima facie passes with property. That means how the risk passes from one person to one person about the goods. Next, action against third parties. Yes, action against third parties. When the goods are in any way damaged, or destroyed by the action against them. Yes, in case if the goods is transferred, at the time of transferring, if it is damaged or destroyed, if the goods is damaged or destroyed, then the action against the third party will be taken. For example, at the time of transferring, if the transportation facility given person is a third party between the buyer and the seller, at that time if any damage happens, then we sue a case against the transportation person, because it's his responsibility to take care of the goods which is transferring from one place to the another place, or which is transported from seller place to the buyer place. Right of resale. Yes, right of resale. So to determine whether buyer can resell the goods to the third party without incurring any liability is linked with transfer of ownership. Yes, here to determine whether the buyer can resell the goods to the third party, to resell the product, the transfer of ownership should be most important. If you are reselling the product, yes, you have to confirm that you are the actual owner of the product and you can resell it to anyone without any disturbance or without any interference of the seller of the product. Next, suit for the price. Transfer of property confers upon the seller the right to sue the buyer for price. Yes, in case if the buyer not pays the full amount, if the buyer fails to pay the full amount of the particular product, whatever the amount is supposed to pay, the seller can sue a case against the buyer for suit of the price. That means whatever the price agreed, if the price is not paid by the buyer, then the seller have all the rights. Insolvency of the seller or the buyer. On the insolvency of a person, the official receiver or assignee takes the possession of the property belong to the insolvent. Yes, that means you purchased on credit basis. Okay, you purchase on credit basis, like on installment basis. You fail to pay the installment. If you fail to pay the installment, then what happens? Then whoever sold the product to you, the seller, he'll come and he'll take the possession of the goods because of fail in payment of the whatever the payment you were supposed to make towards the goods. That is the insolvency of the seller or the buyer. If any party, if the seller or the buyer fails to pay back the amount whatever they agreed to pay, then the opposite person can possess the goods. He will be having the possession of the particular goods. Rules regarding transfer of property. So what and all the rules we are supposed to follow at the time of transferring the property or transferring the goods to one person to another person. The rules for the transfer of ownership are contained in section 18 to 24. Yes, the rules are contained in section 18 to 24 of the Sale of Goods Act 1930. These rules determine the time at which the ownership of the goods is transferred from the seller to the buyer. Yes, these conditions or these rules which comes under section 18 to section 24, they determine the time of which the ownership is transferred from the seller to the buyer. As the general rule, the transfer of ownership depends upon the intention of both the parties. Yes, the transfer of ownership depends upon the intention of both the parties. So what are the rules we have? Transfer of property in case of specific or ascertained goods. Yes, transfer of property in case of specific or ascertained goods. When goods are in deliverable state, section 20 explains when goods are in deliverable state, where there is an unconditional contract for the sale of a specific goods. In a deliverable state, the property in the goods possesses to buyer when the contract is made, and it is immaterial whether the time of payment of the price or the time of delivery of the goods or both is postponed. Yes, in some time the ownership of the property will be transferred from the seller to the buyer on some conditions. So here with respect to this case under section 20, where there is an unconditional contract of sale, if it is unconditional contract of sale between the buyer and the seller of a specific goods in a deliverable state, that means if it is deliverable, if the the goods is deliverable, the property in the goods passes to buyer when the contract is made. Yes, once if it is unconditional, if it is deliverable, then automatically the property or the goods will be transferred to the buyer when the contract is made. When the contract is made, at that time itself the property or the goods will be transferred to the buyer, and it is immaterial whether the time of payment of the price or the time of delivery of the goods. Yes, once the contract is done, okay, they will never worry about the payment or they will never worry about the delivery. They should transfer the ownership of the product and they should give the possession of the goods to the buyer. When goods are not in a deliverable state, section 21, when the contract is unconditional, the buyer will be having the right to possession of the goods even the time of payment of price or time of delivery of goods are both postponed. Even though it is postponed, the time of delivery or the time of payment, the goods ownership will be transferred to the buyer. But under section 21, when goods are not in a deliverable state, in what situation? Where there is a contract of sale of specific goods and the seller is bound to do something to the goods for the purpose of putting them into a deliverable state, the property does not pass until such thing is done and the buyer has notice thereof. That means in some situations the contract has happened, after that to deliver that goods some additional work should be done to that particular product. That situation, at that time the seller can't deliver the goods to the owner or to the buyer. That situation explained under section 21. So if goods is purchased, if payment is also already made, the goods is not delivered until some adjustments or some specific modification done with respect to that goods. Next, transfer of property in case of specific goods or uncertain goods, the same thing. When price of goods is to be ascertained, section 22. When price of goods is to be ascertained. So where there is a contract for the sale of specific goods, where there is a contract of sale of specific goods in a deliverable state, but the seller is bound to weigh, measure, test or do some other act on thing with reference to the goods for the purpose of ascertaining price, the property does not pass until such thing is done and the buyer has notice thereof. Yes, that means section 22 explains when price of goods is to be ascertained. So until measure a product, okay, until measure a product or until you weigh a product, you can't say the price of the product. So in those situations, so what the buyer is supposed to do, the buyer is supposed to wait for the price of the product until the seller measures or weigh the product or whatever the procedure you're supposed to do to determine the price of the product. So he's supposed to wait for the price to be confirmed by the seller side. That is explained under section 22 of the Sale of Goods Act 1930. Next, goods must be ascertained. Yes, section 18 explains about goods must be ascertained. Where there is a contract for the sale of unascertained goods, no title of property in the goods is transferred until the goods are ascertained. Yes, the goods should be ascertained. The price should be determined. Then only the ownership will be transferred from one person to another person. If the goods is not ascertained, if it is unascertained, then the title of the property will not be transferred to the buyer. Next, appropriation of goods to the contract. Yes, appropriation of goods to the contract, section 23. The term appropriation means the process by which the goods to be delivered under the contract are identified and set apart with the consent of the seller as well as the buyer. The seller may appropriate the goods in one of the following ways. So here what he'll say, appropriation of goods is nothing but appropriation means the process by which the goods to be delivered under the identified and set apart with the consent of the seller and buyer. So in what way we are supposed to sell the goods, in what way we are supposed to transfer the goods from one place to another place, that should be decided by both the seller and the buyer. Then only they can transfer the goods from the seller place to the buyer place. So with this, I'm going to wind up this session. I'll come up with few more new topics in the upcoming session. Until then, thank you all. Have a nice day. Namaste.